Do you know a way around the permanent bar for multiple entries?
Oh, great question. This is a segue to our success story today. Today's success story is about somebody with that bar, and they got referred to detention, and they have an immigration judge, and the case was closed years ago. Recently, it just got reopened in June of this year. We went to the first hearing, and then it got calendared in October just a few weeks ago, and then the 45 got approved. Okay, so again, backstory, client came into the country with a tourist visa, overstayed, multiple entries. Now there's a 3-year, 10-year bar, arguably a 10-year bar. Child is a U.S. citizen, filed for adjustment of status. USCIS denies the case. Sorry, you need to, you have this permanent bar. You need to leave the country, and referred to immigration court. And the immigration court, because they saw the adjustment status potential, closed the case. You know, hindsight is 2020. Everybody will say, you should have just applied for adjustment status at that time. You shouldn't have closed the court. But who's to say, right? Hindsight is always 2020. Should have done it back then. You would have gotten a green card. You would have been a citizen by now. But they didn't do that. Case was closed. At least they stayed in the country with their U.S. citizen children and spouse and everything. Fast forward till this year. Filed for parole in place, because if the issue was USCIS and the courts did not accept that they had lawful entry, even though they entered with a tourist visa. Filed for parole in place because, again, the children was serving in the military. The parole in place got denied. Why? Because USCIS said there was lawful entry. Oh, parole in place said there's lawful entry, and the parole in place was denied. Hallelujah. At that time, the court reopened the case, and now there's a hearing. At the first hearing, just within 1 month of getting that motion to reopen, Nicholas, Emily went and presented everything to the judge. We have the 485 ready. We can do the merits hearing right now. Let's do it. U.S. citizen child, adjustment status ready, lawful entry. What's not to like? No criminal record, good moral character, wonderful family, wonderful mother. The judge calendared as fast as possible within a few months. And in October, the case was approved. There's so many takeaways from this, so many. First of all, if you get recalendared, it might not be the end of the world. It might be the perfect opportunity to start a new beginning, right? And again, luckily for this client, they were working on this case with the parole in place and preparing everything months before, right? The second thing is, if you have a choice between going to adjust status with the court or adjust status with USCIS, the conventional wisdom, most immigration lawyer, ChatGPT, a lot of people will say, do it with USCIS. Everybody likes USCIS. There's a whole process in place. Well, not in this case, right? Actually, for the people who go day in and day out in immigration courts, if you have the window of opportunity, do it at the courts. Why? Because the judge has the authority. The judge is already doing the merits hearing. If you have a clean case, let the judge do it, get it approved. The card comes. You can skip that entire transfer process, which might prolong the case by another half a year to a year plus. USCIS, immigration officers, a lot of them are not necessarily attorneys. Most of them are not attorneys. Some of them are, and they don't necessarily like to deal with these complex type cases. But a judge is used to doing way more complicated cases. But when they get an easy case, such as a U.S. citizen, lawful entry, or paroled in, and can file for adjustment and everything qualifies, to them, it's an easy case. Get it off the docket, get approval, check their quota, feel good day. June, the client's family couldn't sleep. And that was during like the raids, you know? Couldn't sleep, motion to reopen, calendared, stressed the heck out. But a couple months later, they got the green card. Been waiting for years, you know? I love the legal strategy that was done in this case. Emily was the mastermind behind this, essentially filing for parole in place, trying to seek a pathway there. Got a denial, unfortunately, but with that denial notice, USCIS admitted that there was lawful entry. And with the lawful entry, now you can go give it to a judge. You know, like, just love the whole nature of this. So that's a success story for today. Just want to share all the details. Hopefully that helps. If you have a case you've been here and you were in deportation proceedings and the case was closed, you are actually in a better position than if you're purely 100% undocumented. Because if you're purely 100% undocumented and ICE picks you up, now you're put through the worst of the worst system. But if your case has been closed, you're essentially safe. But you should start preparing your case in case they reopen it. And if it's reopened, you have a good marriage argument and potentially can get the green card. There's a lot of pressure on the government to reopen a lot of cases that they closed in the past decade. You have time to prepare. You never know when they're going to reopen. It's a matter of if and not when. They're going to open it. So better prepare now.